for the hearing in the appeal, Warren and State.
Yes, morning, Ms. Ellis.
Thank you. Wash up issues from yesterday. It just in the context of what my friends say in their submission at 1.13.
1.13.
1.13.
Yes.
They say that the case has generated
Yep.
some 2,000 pages of submissions, 14, 30. 60 days more, 50 procedural minutes, 30 judgment. So trying to find where anything was or remembering it is no mean feat. And what I've done is I started at the beginning to look for where these things arose. And it's not surprising that people can't remember when something was argued. So you've got two documents, I hope, in front of you. So on the first short one,
What are they described as?
there's the revised submissions,
Yes.
applicant appellant,
Yes.
and paragraph 4, I've only given you the page, paragraph 402 is honour lacks structural independence by controlling the mission of the bar, thereby compromising his independence and confusing executive function. And the Fuller document, which is of the 21st of July 2014. If we go to paragraph 102, I mean, it's quite a lengthy set of submissions.
Sorry, can I just understand, what is this?
This is submissions of the applicant arising from the memorandum of the Chief Justice.
But wait a minute, made where? To the Supreme Court,
To the
judging by
Supreme
the back sheet.
To the Supreme Court, yes, I see.
And,
Yes, I see. Oh, this just shows it's not a new point.
yes, yes.
Yeah, all right, okay.
152, in the role of appointing and removing members of the bar, the Chief Justice has referenced the pool of eligible lawyers for Pitcairn bar, but has given no legitimate reason to do so. It's wrong in principle. It's compromised the independence of the bar judiciary for the Chief Justice to have a role to play in selecting members for admissions. It's particularly troubling that the Chief Justice has removed
Yes, good. No, that's helpful. That,
and the rest of that.
what are the date of the first lot?
Was
The revised submissions?
the first
No, the second.
of 21st of April,
Yeah.
or, sorry, the 27th of April, 2002.
2002?
2012.
Well, right. Good. So there's two, and that's very helpful.
And then in the judicial review statement of claim, which is in the one of these bundles. I should find the minutes. I didn't know what my bundle was. I think it's volume 2, document 0543.
All right.
Two.
Yes?
Yes, and that, in the context of that, if you might recall, was that the statement of claim eventuated between discussions between the parties, and it was really an attempt to conceptualise and organise in some meaningful, structured form all the submissions that have been filed, all the claims.
So we can cross-check that, can we, and see what
Yes, so if we look
was
at
being raised.
113 and 114, 4 on page 0559,
Yes?
we see in relation to the consultation
Yes?
issued on March 2010 by media release issued by the British High Commission under the headline Governor proclaims new constitution. The release included an obligation for the Island Council to be consulted on draft legislation. The Island Council was not consulted on draft legislation.
Sorry, where is the obligation in the Constitution to be consulted?
There's no obligation in the Constitution, as far as I can see, how the authorities determined what it meant, and they're giving a...
Well, what meant? Which element are you submitting that the Constitution does include, impliedly, an obligation for the Island Council to be consulted on all draft legislation?
Well, one might be able to get it out of the partnership values in Part 1 of the Constitution. But whether or not you can do that, there's a legitimate expectation that you will be consulted, because the government said so. And remember, Mr. Warren has a dual function here. He's mayor, plus he's the accused at the time, so he's going to be consulted as the mayor, and he wasn't. So it's not a new issue. I think that...
I mean, would this relate to anything more than legislation by the Governor on the advice of the Island Council? Let's just look at the Constitution, which
which is 9.
It's 36.1, isn't it?
Yes. Yes, it says, surely what they were referring to is the Governor acting after consultation with the Island Council.
Yes.
Yeah, well, that relates to local legislation.
Yes, I'm not sure that it relates to legislation that's going to be laid before the UK has to follow. But nevertheless...
So, I mean, the question you have to address is whether the Constitution or the United Kingdom in some way held out that if and insofar as the United Kingdom exercised its powers under the 1867 Act, it would also consult with the Island Council. And
I think
isn't that you accept that's the question? Yes.
yes, and in the spirit of the Constitution, that there will be consultation, and also in respect of Section 20, the natural justice right, that everybody's rights are adversely affected.
I mean, this amounts to a well, I suppose in one sense a fetter, but in another sense you would say a legitimate expectation that before enacting UK legislation, the UK will take advice.
Yes.
The subsection 3 of section 36 rather implies the contrary, doesn't it? Because the governor may exercise the power without consulting the Island Council whenever he or she is instructed to do so by Her Majesty through a Secretary of State. That rather emphasises that legislation through the UK government is excluded entirely from the scope of this provision.
Well, that's one possible reading of it. I accept that. In the context of a constitution and a statement by the UK authority, the British High Commission, that there will be consultation. And in the context of what is supposed to be democracy, it is, in my submission, unthinkable that legislation is going to be introduced without consulting the island, particularly given the Constitution and the importance my learned friends attached to the proposition that there was full consultation on the Constitution.
But you've got to show that this goes to the validity of the legislation, haven't you? I mean, there's one thing to, as we know from recent decision in the Miller case, the Article 50 case in this court, in the Supreme Court, that it's one thing to talk of a convention, it's another thing to talk of something which affects the validity of legislation or an act.
Yes, I can see that. But I say that this does affect the validity.
Yes.
Because it is strong in principle to introduce legislation and not involve the population that it claims to affect.
Right.
It is not something, it may be something that Lord Denning might have taken with many moons ago, but in the modern language it is unthinkable that a government will behave like that. That is not a democratic structure which the Constitution by 8 times said. It's just unthinkable that you deny the right to effectively petition Parliament. That is denial of access to Parliament, and Section 36(3) of the UN.
I mean, what are you saying would have happened? You're saying that there might have been a prospect, or would have been a prospect, that Parliament would have said we shouldn't validate the appointment of these judges.
Yes, that would have been the submission. Mr. Warren from Europe, and MPs would have been lobbied, and there would have been hopefully a discussion, if not a motion, to disallow the order laid before.
I mean, what factors would you have put forward?
Well, that's it. The factors that I put forward in the submission, that it is wrong for the government to alter the process during the cabinet.
I see. So it would have turned on the ad hominem point.
Yes, or ad hominem and retrospectivity.
Yes.
But that opportunity didn't grant me. I don't want to say more. It's time.
No, well, we want to just check that we've covered everything.
I think I have.
Yes, right. Well, we better move to Mr. Edgeler.
Thank you.
Yes.
Thank you for allowing me to address you. It's really two of these specific issues which aren't systemic. I think there's probably a third non-systemic issue that my learned senior raised, being the island magistrate's personal interest is not something that's systemic. It's particular to this case, given he was deputy mayor and Mr. Warren was mayor. That has been dealt with, and so the two issues, and we're starting at page 94 of the submissions at paragraph 391. The first non-systemic issue, the submission that the offence Mr. Warren was convicted of
Was not in force. Yes.
was not in force.
Right.
And so that offence is the English offence under section 160 of the Criminal Justice Act. And the basic submission, it comes down to the interpretation of section 42 of the Constitution. Laws of general application in force in England apply on Pitcairn, and it's accepted that this is a law of general application in England. But under subsection 2, only so far as local circumstances permit and subject to any existing or future ordinances. And the basic submission is the summary offences ordinance is an existing ordinance that effectively covers the field. They're not identical provisions, but they are very similar provisions, and certainly Mr. Warren could have been convicted for the acts he was alleged to have done under the summary offences ordinance. And my friend's proposition is effectively that where there are two offence provisions that can both be charged under, the Crown gets to choose, and of course that's true, but they both must be in force. And if one isn't, you don't have much of a choice left. And the submission in this case is Section 160 is not in force. So the choice that they could otherwise perhaps have had, they don't in this case. And why they say Section 160 is in force is, and why they wanted to elect that, is the seriousness of the offence. That if this had been a summary offence under the Pitcairn Summary Offences Ordinance, the maximum penalty Mr. Warren could have faced would have been 100 days imprisonment, and under the English law, which they opted to charge him, they could have gotten a sentence of up to 5 years, and indeed did get a sentence well in excess of 100 days. But that ignores something, I think, important about both the English law and the Pitcairn law. When the latest iteration of the Pitcairn Summary Offences Ordinance was adopted in December of 2000.
Right.
The current version of the Section 160, at least as it applies to Mr. Warren, was adopted in November of 2000. 1 month apart, the Governor, as the legislature of Pitcairn, is presumably aware of changes in the law that have taken place in the United Kingdom, perhaps also in New Zealand, given the provenance of the Governor's legal advisors being New Zealanders, and would know, look, the Parliament of the United Kingdom has said this is now a more serious matter. It shouldn't just be the summary offence that it used to be in England, with a maximum of 6 months imprisonment. And the Governor has made the election when adopting the latest version of the Pitcairn Ordinance. No, I'm happy with the offence as it was, a maximum of 100 days. And the submission that this is so serious that, of course, this must apply seems unsupportable, might be going too far, but I'll probably adopt it anyway because I can't immediately think of a better word. Until November of 2000, the maximum penalty for this offence under UK law, or under English law, was 6 months imprisonment, a summary-only offence.
Sorry, Section 160 was summary only, was it?
Yes, until November 2000.
What other alterations, if any, were made with effect from November 2000? And can you just, without taking us to it, just give for my note, tell me what made those alterations? Because it's in a 1988 Act, isn't it?
Yes, it was.
Wasn't there a, what about the Protection of Children Act? Wasn't that enforced before that?
I'm trying to think that, I think it was either the Protection of Children Act or a Crime and Criminal Justice sort of large-scale amendment that just amended a lot of things, and this was one of them.
If you've got the details, tell us, but if not, we'll look it up. But there
Yes.
were other UK or English offences, were there not, covering much the same ground as Section 160?
I think there may have been, yes.
You've got those set out anywhere?
No,
All
not
right.
submissions.
Well, we'll
No.
find them.
Let's just get straight.
Yes.
We haven't got the Criminal Justice and Court Services Act 2000, which is the relevant act.
Yes.
What is the... when was it enacted? It came into force, you say, in November 2000.
Yes.
Yes, it was, appears to be enacted 30th of November. And came into force on the same day? No.
That was my understanding, but
Well, All right. So,
It-
on
it-
that basis, at that stage, what was the law in Pitcairn in this area?
It was effectively the same. The summary offences ordinance, a previous iteration of the summary offences ordinance, had a maximum penalty of 100 days for possession of indecent objects or objectionable objects.
So the summary offences ordinance we've got here at tab 45 is
Yes.
a reiteration, is it?
Well, that offence at least, I may have been changes in other offences, but that offence is unchanged in December 2010.
Which section is it in the Summary Offences Act ordinance?
8.
8, yes, here we are.
Page 95 of the submissions.
So this reflects, you say, precisely some previous.
Yeah, well,
And so you would say that because it's there, the UK Act can't have effect. But that why not? If the UK Act was obviously designed to deal with more serious offences and increase the penalty, why wouldn't it, as at 30th November, have the effect of doing so in Pitcairn?
because of section 42, subsection 2 of the Constitution.
No, but we're dealing with some previous iteration of Section 8, you tell me,
Yes.
of the Summary Offences Act. Is that right?
Yes. Well,
So it's there. Now, if we look at Section 42 of the Constitution, shall the English legislation coming into force on the 30th of November shall be enforced in Pitcairn so far only as local circumstances and the limits of local jurisdiction permit. Well, is there anything in local circumstances which would make it inappropriate to apply the same increase as has been thought appropriate in the UK?
the fact that 1 month later,
1 month later.
the governor of Pitcairn passed some legislation setting out a maximum penalty of 100 days
No,
for
but
the offence.
you tell me this reiterates, this does no more than reenact something that existed before
Yes.
November the 30th.
And
So we
if-
have to ask, and presumably, you're also saying that the UK legislation, in fact, abolished a UK summary offence.
No, if you turn to
Let's look at that.
page 96, I've got the section 7. Effectively, that's section 160 of the Criminal Justice Act.
Yeah.
It was subsection 1, subsection 2, subsection 3, so there was still a summary offence in
There's still a
England,
summary offence.
and it added subsection 2A, so an indictable option.
So in both jurisdictions, the position prior to 30th of November 2000 is that there is a summary offence.
Yes.
In both jurisdictions after November and December, there remains a summary offence.
Yes.
But in the UK, it's been thought appropriate to add on a more serious, to introduce a more serious offence.
Yes.
It's to make it indictable,
Yes,
isn't
to
it?
make it indictable. It's the same offence. if
It's
you
section 41, if I've got it right, of the Criminal Justice and Court Services Act, which amends section 60 by inserting after subsection 2.
It would have helped to have the 2000 UK Act.
Yes, sorry.
It inserts 2A,
Yes.
which you have set out in your synopsis, and it effectively makes the offence now both summary, well, it becomes a hybrid offence.
Yes.
Okay. Trial, hybrid offence. So that's, and you say that's with effect from November 2000, is that right?
Yes.
All right.
1 month later,
Yes?
restating Pitcairn law, the governor chooses not to make a hybrid offence in Pitcairn.
Yeah, I see. So what you're really
I
saying
see.
is that the governor, if he'd contemplated the more serious offence, would have inserted 2A into the Pitcairn
Or
legislation.
done any other number of ways.
Yes.
Wholly separate offence, just for...
Yes, of course, the summary offence is not about children.
No, it's a general.
I mean, I understand your point that 160, as amended, creates an offence of possessing what I can loosely call child pornography, which may be prosecuted either summarily or on indictment, as from the amendment in 2000, yes?
Yes.
But the Section 8 offence is not an offence of child pornography, is it? It's an offence of possession of indecent material.
Yes.
And I can't, I'm afraid, remember whether, as at 2000, there was such an offence in England. But I suspect not. There was certainly an offence of publishing, but whether there was a possession offence, one would simply have to look up. Do you know?
I thought there was. I don't know.
Yes, all right. Well, if there was, then that makes it even clearer.
But again, the alternative, if the governor of Pitcairn, acting as the legislature, had decided, oh, look, the Parliament of the United Kingdom has just passed a law with effect to England, recognising that child pornography is serious enough that it needs to be punishable by a sentence of more than 100 days, then in Pitcairn, the governor of Pitcairn could have made a separate child pornography offence. But passing a law...
But he's absolutely no need to, because of Section 42. Isn't that right?
Well, the submission is that possession of indecent material, which...
Yes. Covers the same ground?
Yes.
But it doesn't, does it?
There is no charge of possession of child pornography. It would be open to the prosecution here to charge Mr. Warren for possession of child pornography under the local ordinance. And in fact, he was charged with 5 charges under the local ordinance and convicted of 2. And so it clearly could cover the type of offence which they charged him under Section 160.
Certainly.
And given that there is a Pitcairn ordinance, given that subsequent to this, because the Constitution in Section 42(2) was, of course, some 10 years later, the Constitution and the limits of local circumstance and existing and future ordinance bit was brought in, was after the amendments to the UK Act, that it is up, if the governor wants to increase the penalty for a subset of Section 8 offences, could do so and has not. And
tell me, before the UK Act of the 30th of November, there was in English law a specific offence of having an indecent photograph or pseudo-photograph of a child.
yes,
And that was punishable by what?
summarily 6 months.
Summarily 6 months. So while you describe that as a subset of Section 8, it appears to be, in fact, a specific child-related offence, whereas Section 8 is unrelated to children specifically. So could not a person have been charged under the UK summary offence prior to November 2000?
I would have said not. That Pitcairn has passed an ordinance, maximum of 100 days. The fact that England...
But that's not... presumably England has offences of obscene material which are not
yes.
child-related.
Yes.
Yes, so that they would overlap with Section 8, but a specific offence relating to children, which is Section 160, while you may describe it as a subset of Section 8, in fact, it coexists in English law separately from the equivalent of Section 8, whatever that is. We can no doubt find it if we have the whole Act.
I'm trying to remember what Lady Chattersley Lovell was prosecuted
Yes.
under.
So even before November 2000, you had, on one view, a possibility of prosecuting under Pitcairn law, firstly under Section 8, secondly, if it was a child-related offence, under Section 160 of the English legislation, And that latter possibility, if it existed, was simply accentuated by the change in, well, to make the offence an indictable one on the 30th of November 2000. That's the view I'm putting to you as a possible.
Yes, yeah, and the submission would be, or is, Pitcairn has Pitcairn laws.
Yes.
And if there is something that could not be charged in Pitcairn,
I've got.
oh, we don't. Yes, yes.
And we probably need to look at the whole of the 2000 legislation to get a picture of the.
From memory, it makes a large number of changes,
But
rather diverse.
you've accepted that there would have been a general indecent or obscene material section apart from section 160.
Yes, I'm not sure if it's in the Criminal Justice Act or somewhere else.
Yeah.
Well, it's probably in the Obscene Publications Act, but it
Yes.
may not be. There may well have been other places where it was, and we'll have to look at it. And I can't put it to you, and I'm not going to try and do it on the hoof. Be careful about this, because avoid responding without thinking about it. But at some stage, you will need to think about the Protection of Children Act 1978, which, since 1978, made it an offence in England to take or make. Wait a minute, let me just check when that was added. Make added in 1995, but to take or make an indecent photograph effectively of children. It was an indictable offence, and it was punishable initially with 5 years, and from 2000 onwards by 10 years, maximum of 10 years. So, and of course, downloading on a computer is making a photograph in English law. So that you need to factor in, and we shall need to look in due course into your contemplation of what the position was as at 2000, that quite apart from section 160, it had been an offence, a specific separate offence. There were specific separate offences relating to indecent photographs of children, which were punishable on a much higher level than simple possession of indecent material.
Yes.
Okay? So it wasn't new, by the look of it, at the end of 2000, or even in 1988. Well, yes. I'm not going to ask you to respond to that now, Mr. Edgley. It's not fair. It's brand new. You may or may not need you may or may not think it affects your core submission, which is that the governor opted in 2000 to limit the Pitcairn law to the summary ordinance. But you should have the opportunity to put it in writing afterwards if you want to.
And I think we should also see the reincarnation or the previous incarnation of the summary ordinance.
Yes.
You tell us, I'm sure you're right, that Section 8 is not new, but
Yes.
it would be helpful to have a copy of the prior ordinance to the same effect. Since we're trying to consider the interrelationship, and we have to consider what was the position on the 30th of November on the face of it,
Yes.
which is before this ordinance. Because if the position was that Section 8 went hand in hand with the new legislation on the 30th of November, it doesn't seem to me that, the predecessor of Section 8 went hand in hand. I'm not sure that the reenactment of Section 8 is material. It would just be a reenactment of something that would go hand in hand with Section 160 as expanded.
Yes, I mean, the submission would be, given that there is an offence, even if there had not been a reenactment in 2000, the submission would be the same. It was the Governor of Pitcairn can legislate for Pitcairn. If there was a concern in Pitcairn that images of child sexual exploitation were something that needed concern, that the Governor could have done something about it, I suspect. Wouldn't have, given, I'm not sure when Pitcairn got the internet. I suspect it didn't in 2010. In 2000.
Well, we better move on, yes.
Yes. Yes, and so I mean, the next bit, again, given the location in New Zealand, the other matter is looking at, is this something that is particularly serious? And you've mentioned the position in England at the time of the child protection legislation. Also give reference to the New Zealand legislation. It wasn't until 2005 that possession of child pornography became imprisonable in New Zealand at all.
Right, well,
So that this is not something that there have been changes over time. This has become a matter of much greater concern, properly, and that's a concern that the Governor could have taken up at any time, given that there was already an offence that could have been charged. The other, effectively, unless there are any further questions on that point, the other matter I'm effectively dealing with is over at page 146 of the submissions, which is the specific search in this case. Part of that already having been dealt with the submissions around
systemic.
the specific submissions about the search warrant being authorised by the Deputy Mayor, who
Right.
possibly stood to become the
Right.
Mayor. So that's a something that isn't systemic, but so closely relates to
Right.
independence of the judicial system. And so we have...
Well, you say it was specific. It's not anyway,
If it
there's a
was
systemic point, but there's also a specific point, because
Yes.
it goes directly to this
Yes.
case, and we discussed the fruit of the poison tree with
Yes.
Dr. Ellis. Yes.
Yes, and that's effectively what I'm to discuss, that and whether it's under English common law or Pitcairn common law, as the case might be, or under the Police and Criminal Evidence Act, if the search was unlawful, and the submission is that it is, for a couple of reasons, the one raised yesterday, and also the argument that the Police and Criminal Evidence Act, once we've worked out what laws of general application are and how they can be enforced in Pitcairn, particularly if I'm wrong about section 160, that if that's the approach, that laws of general application in England can be enforced in Pitcairn, even where there is something in Pitcairn law which covers issues, then that, what I would call a wider approach to the application of English law, should apply to other statutes, including, for example, the Police and Criminal Evidence Act.
Right.
Which particular bit of it?
The bit of it, I'm not sure I don't know that section, it's not something I deal with.
Yes, it's a section on search warrants, is it?
Yes, the section on search
Which
warrants
is?
in particular, section 78.
No. 78 is the general provision for exclusion of unfair evidence.
Yes.
But have you got in mind the specific provisions in the schedule to the Police and Criminal Evidence Act which govern the issue of search warrants? Or not? No, obviously not.
Well,
I'll get the right one. Yes, it's not something that New Zealanders deal with at great length. Memory, it was the...
We don't have the Police and Criminal Evidence Act, do we? Right, well,
No, well, all I wanted to know was which bit you were relying on. It's obviously not any of those bits. Right.
It's effectively a couple of points. One, the Police and Criminal Evidence Act allows search warrants for indictable offences.
Very broad proposition. You'll have to take
Section 8.
Section 8?
Page 150 of my submissions, I've got Section 8.
Page 150.
150, yes, paragraph 632.
Yes, Section 8. Yes, it's reasonable grounds for believing that an indictable offence has been committed, isn't it?
Yes.
Yes.
Reasonable grounds for believing that indictable. And if you look at the search warrant. The search warrant is issued for the summary offence under Section 8. The application for the search warrant was, I'm looking for evidence of an offence under Section 8 of the Summary Offences Ordinance. Neither the application nor the search warrant itself was Section 160 of the Criminal Justice Act, the indictable offence mentioned. And so if the Police and Criminal Evidence Act provisions around what justice can issue a search warrant it could be issued for an indictable offence, but the application was not for a search warrant for an indictable offence.
Are you saying that the effect of Section 42 of the Constitution is to, as it were, incorporate, first of all, to incorporate the Police and Criminal Evidence Act, including Section 8, and secondly, that the specific power in Section 8 to issue a search warrant with respect to an indictable offence excludes a search warrant issued for anything else? It must be, I think.
Essentially a back-up submission that I would have said Section 160 doesn't apply at all, and that your approach to what applies from English law in Pitcairn should be a narrow one. Pitcairn has a law that covers the issue, use Pitcairn law only.
That's the Justice Ordinance.
Yes.
Section 23 authorises this search warrant.
Yes.
Yes.
Yeah. So what are we saying? That PACE is incorporated to overrule Section 23? That's...
Certainly where someone is looking for evidence of an offence against English law, the protections...
They weren't. Yeah, they did. The search warrant, as I understand it, was issued in respect to the summary offence.
It was, yes.
Ordinance offences. So, in terms of Section 23 of the Justice Ordinance, it was authorised.
Yes.
And the material, once discovered, demonstrated it was, as the prosecution suggests, a more serious offence. Can't they rely on that?
Said that the evidence they got was the evidence exactly what they were expecting. They were expecting to find...
The real submission is it because the search warrant was issued under Section 23 of the Justice Ordinance, any material which was found could be admissible only in relation to a summary ordinance offence, is that it?
In the specific of this case, yes. I accept that if they'd gone there and found a dead body or something.
Well, quite.
But given that they found exactly what they were expecting, they applied, and it's...
Well, how do they know it was children, for example?
Supposing they find it's terrorism material.
Well, it was that the search warrant application certainly gave the indication.
Yes, but so what? Point is, well, first question is there a power to search? Answer, you say, as I understand it, yes, under Section 23.
Yes.
The next question is, when something is found, is it admissible in a subsequent trial?
Yes.
And you, I think, are saying that if you've applied for your search warrant having in mind the summary ordinance offence, then even if Section 160 is operative in Pitcairn, if it isn't, all this disappears, but even if Section 160 is operative in Pitcairn, you can't, anything found is inadmissible. That's how it works, is it?
Yeah, for other reasons.
Well, as I say,
yes.
supposing they'd found on the computer all kinds of bomb-making instructions,
Well,
which actually tends to happen quite a lot here.
That would be something that they could prototypically charge them under Section 8 of the Ordinance with.
I beg your pardon?
Wait a minute, not
Bomb-making material, I think I don't know that it would be in dispute that bomb-making material or other terrorist-related material would be offensive. This person has terrorist-related material on their computer, he could be charged under Section 8 of the Ordinance with the summary offence.
Well, I think
No, wait a
it's
minute.
indecent or obscene, isn't it?
Yes.
Well,
Sorry, yes. I keep using the objectionable. Objectionable is the term in New Zealand, and I suspect it's come up by more than one.
But anyway, you are saying that, are you, that as long as we understand it, that's fine, we'll think about it. But you are saying that if they had found bomb-making material, the only offence, the only situation in which it could become admissible is if he was tried under Section 8 of the Ordinance.
Yes, yes, certainly. If
Okay, well,
I think you also have a variant, as I understand
Yes,
it,
yes.
don't you? Namely, that if the information which they had available at the time suggested an offence under Section 160, if Section 160 applies, then it was improper to suggest that the potential offence which was interesting them was simply an offence of indecent or obscene material, and they should have come straight and observed what you say are the limits to section 160 search warrant, namely those found in section 8 of PACE.
Yes.
So it's a sort of integrity point that
Yes.
You rely on as a sort of alternative. As
And buttressed by the particular, the search warrant being sought of the island magistrate. The island magistrate does not have jurisdiction over laws that are in force under section 42, that is English laws. So if you turn to...
well, that's a further point.
Yes, yes,
does
it
not
is.
have jurisdiction over English laws under section 42. Yeah.
So that's if you turn to page 148, paragraph 625 of the submission.
Twice, paragraph 65, yeah.
Section 5, 1b, Roman 3 of the Justice Ordinance, which limits the jurisdiction of the island magistrate. So it's that if they wanted to search, if they thought it possible that they might find material that would lead to a charge under English law, they should have made their application for the search warrant to one of the off-island magistrates, of whom at the time, and I think now as well, there were 4 with legal training, which the island magistrate is some training, but not legally qualified.
Is this point was raised below?
Yes, very much so. Probably don't need to go through it now, but at page 147, and some of it will be in the chronology as well, there's some of the background material of what sorts of consultation work took place before the search warrant was applied for. So it was the New Zealand Police, as New Zealand Police, and also English police, where their advice was sought before the application was made. So it's not just a matter of the local Pitcairn police officer, oh, I've got to go to the island magistrate without being quite sure of what's going on. There was a lot of care taken before the application was made, and it should have been.
Have you got any evidence to suggest that they did think that a section 160 offence was involved? Or they had very little information. They had a rather odd email address.
Yeah, and the information that they found online when they searched for that email. So I suspect the search warrant application is in the...
Let's have a look at that then.
Sorry. Volume. Two. Go.
Is it perhaps 845 or not? Sorry, that's the warrant. Beg your pardon.
So what's the reference?
Volume 3,
Yes.
page 790.
Thank you. essentially searches by the police officer, having found the unusual email address, then, oh, I wonder where this email address has been used on the internet. And various websites had records of the internet, of the email address being used. One where children are described, at least, people under the age of 15. And various material which clearly suggests it's not you're looking for general and decent material. One particular example would be page 793.
Yes, it is.
Yep. 15 and discussion. It's clearly in the minds of the police officer and the others who found this, that there was the possibility of children being involved. Certainly the submission at the trial in relation to some of the chat transcripts which formed Mr. Warren's summary convictions, as he was convicted of 2 summary offences, one in relation to some of the transcripts that are similar to what's here, was that factually it wasn't proved, but certainly there's the reason that this was thought so serious to warrant a search warrant was concern on the island, particularly given the history of the island, that there might be child-related material.
Is there somewhere an indication of photographs as distinct from indecent discussion? There may well be.
There certainly weren't actual photographs that they found beforehand. I had thought there were discussion of sending photographs. Can you send me a photograph? But that might have been discovered afterwards.
Well, there's a reference to 15-year-olds in paragraph 16. After that, I think they're a bit older.
There are other references to paragraph 74 has a 74.
74.
All this stuff is found on the internet, is it?
Yes. There was a website where the email address was linked and there was discussion
So
of...
you say, I mean, there are references to children and that's... they must have suspected indecent material.
Yes, not proved, but... You know,
Well, paragraph 77
77
says that on the basis of that information, I believe that he's committed the offence of possession of obscene articles.
Now, what I'm after is whether there's an indication anywhere that they thought that there were photographs of the children.
And paragraph 77 doesn't finish.
It doesn't.
Yeah.
It's left in the air.
As I'm aware, I don't think there is a paragraph... I don't think I have seen an application where the paragraph 77 did finish.
Right. All right.
This is the search warrant
I
application.
think we see the point you're making.
Yes.
Namely,
That was the jurisdiction of the island magistrate. That the submission, and certainly submission in the lower courts, was made that they made the application under the Summary Offences Ordinance only describing the summary offence because they wanted to make the application to the island magistrate where that was not required.
Oh, you said they deliberately tailored it to
Yes,
the summary offence of indecent material rather than photographs.
Yes, if they had put in
no,
section
but
8
do we
and
know
section...
that? Do we know that? It's a submission or an
It
assertion.
is a submission.
But do we know it? Was it asserted before? Is there evidence?
It's been asserted before, yes. The submission has been raised that when you look at the material, it's a question of can you draw the inference? It's not something that was accepted. You know, I mean, Mr. Medland, the island or the officer at the time who made the application, Sergeant Medland, was cross-examined a couple of times. I don't think he accepted that that was true. The submission was made. and has been made.
Well, was there any finding after his cross-examination?
No, well, not. Yes, there was a finding. That is that.
Where's the finding? Who was he cross-examined? He was cross-examined. Well, show us where the findings are.
Yes, Justice Lovell Smith's judgment and Justice
Lovell
Haynes's
Smith.
judgment.
Let's look at them.
Certainly the finding it's been the finding throughout that the application was lawful and the warrant was lawful.
And made in good faith?
Yes.
Yes, well,
Well, in that case, what do you want to...
why are you making the submission that it was not? I mean, let us look at the findings anyway.
Justice Haynes' judgment is at tab 7.
I think you said it was Lovell Smith, didn't you?
Yeah, I said both, my lord.
Who, in front of which of the judges was the sergeant cross-examined? That'll answer the question. Oh, both. Oh, all right.
We didn't succeed on our point that the warrant was unlawful.
No, we're interested in the question of state of mind, though, and since
We lost everything in relation to the search warrant. There's no finding in our by either of the two.
so we can assume, can we, that the finding is that the warrant was issued because the officer thought that summary offences were committed, and it was put to him that he knew that more serious offences were committed, was it?
Yes, it was.
And he, what his answer was, no, I only thought at that stage that it was material justifying a search for summary offences. Is that
No,
right?
I think he took advice from both senior officers in New Zealand and in the Kent Constabulary, I think, who were guiding him as to what to do and suggesting that more serious offences should be charged. And he took advice on how to charge for more serious offences.
Yeah. All right. Well, if you can give us the references, that would be helpful to where the officer's evidence is dealt with.
Yes. Yes, I'll have to look it up.
Well, the answer is, why don't you take time and not do it in court? Are those your submissions? Have you got other points to deal with? Because
Final submission. Whether PACE is in force or not.
Yes.
That if there was some legality, I still have to argue that the evidence should be excluded.
Yes.
The fact that there was an unlawful search for whatever reason or an unreasonable search for whatever reason.
Right.
Those submissions are briefly dealt with very near the end at 154, or page 154 and on. That given the nature of the search, an invasive search not just of Mr. Warren's home, but of the mayoral office and computers and the various information that was found, coupled with the submission that the search warrant at least was a search for a summary offence.
Yes.
That when you're looking as to whether the information or the evidence obtained should be excluded, that the submission is given. It's of course on the submission that this was an unlawful search. It was an unlawful search for a summary offence at the time with a maximum penalty of 100 days.
It was unlawful because of, well, you made points about
Yes,
state of mind, but also because of the bias.
Yes, bias and the jurisdiction point about the island magistrate not being able to issue a search warrant under Section 160. And particularly the bias point, I think, is the stronger point for why the search was unlawful, just specifically that.
Can you just tell me where in your submissions, synopsis, you've dealt with the law on the exclusion of irregularly obtained evidence? Sang, Khan, all the rest.
Paragraph 645, isn't it?
That is?
Is it, isn't it?
Yeah, it is a very, very brief.
Would have helped, you know,
Yes.
if you'd started from the proposition that the fact that evidence is irregularly obtained does not make it inadmissible. I mean, it's that way round. It isn't because Section 78 has been enacted in the Police and Criminal Evidence Act that one gets to the question of unfairness. We've always got to the question of unfairness.
Yes.
Nur Muhammad reigned long before Section 78 was even thought of. It's simply a statutory form of a common law rule.
Yes.
But the other common law rule that matters is that the fact that evidence is irregularly obtained does not make it inadmissible. Where's that in your argument?
It is not in the written
all right,
argument.
there we are.
so
Anyway, that's
no,
that.
no.
Anyway, it's now in your oral argument.
Yes, yeah, it was one of those that is the how much do I want to teach you about English law? And it was,
Well, I think
we're at 158 pages already. Yes, certainly it's,
you've got to identify the factors which you say make it unfair to admit this.
the particularly invasive nature of a search, particularly a search of a computer, including a search of the mayoral computer, where evidence or information related to various members of the island was discovered,
Yes.
including Mr. Warren, obviously.
Other citizens, yeah.
Yes.
And that this is is this the excessive seizure point?
Yes.
And do you say that goes to the admissibility of the bits that are not excessive?
It goes to the unreasonableness of the search, and so the more unreasonable the search,
I see.
the stronger the case to exclude the evidence obtained under it.
Is there any authority for that proposition? If we're focusing on the admissibility of something that is directly relevant to a criminal offence, is there some authority somewhere for saying that the fact that something else has been seized which really shouldn't have been is relevant to the admissibility question?
Yes. We go back to 641.
Yep.
There's the decision of the Constitutional Court of South Africa and Minister of Safety and Security and Van der Merwe.
Van der Merwe, yeah.
Yes.
That's just about the
Yeah,
validity.
largely about intelligibility, but again, when you're looking at valid
Was
warrants,
it-
the worst...
Was it a case about the validity of the search warrant? Was it an attempt to strike down the search warrant?
Yes.
Yes. Was it about the admissibility of the product?
That the more illegal the... Sorry.
But you haven't touched on this point yet. This point is that the search warrant is unlawful for a different reason, namely that it didn't identify the section. It identified the wording of the
Yes.
summary offences ordinance, but not Section 8 as such, or the ordinance as such. That's a different point.
It is, yes.
I mean, it might be regarded as a slightly technical point, and it's a basis for saying the warrant is unlawful, it doesn't help you on the question of discretion if it is unlawful, does it?
Not on the question of discretion, no.
No. Right.
Unless there's anything else I can help.
No, thank you. Thank you very much, unless my colleagues have anything.
I will get the reference that your lordship sought.
Go on. Yeah. I think we'll take... Yes, Dr. Ellis, have you got something more to say?
No, I was just going to say that the submissions.
Sorry?
That was the submissions for the...
Thank you very much. Yes. Well, we will take a little time to just think where we are, and we'll come back. We certainly won't be back until 1:15 at the very, very earliest. Yes, Mr. Attorney. We need only trouble you on a limited number of points. First, we would be grateful if you would assist us with the question of permission. What falls within the Section 25 permission which has been given, and what is excluded, and as a sort of sub-point, what are new points, even if they fall within Section 25, if any, which we should exclude. And then secondly, turning to the position of the island magistrate, can you help us on the correctness of the approach taken by Justice Haynes and the Court of Appeal below? They concluded that there was no apparent bias. If there was apparent bias, assume that the island magistrate should not have dealt with the matter because he was the deputy mayor, then the question arises, which we've discussed at some length, about the common law or statutory discretion. If there's anything you want to say on that, we've heard the submissions, but it's mainly the first point. The third point is the interrelationship of the Summary Offences Ordinance and the Criminal Justice Act, and the argument that the former excludes the latter. It may be this requires a bit more homework. It may be you've already got the material, but effectively, as you know, we were left in a position where we thought it would be helpful to know more about the pre-30th of November position in order to evaluate whether what happened when the English Act or the UK Act was passed, and then secondly, what happened when the Summary Offences Ordinance was reenacted in December. We have identified the findings of fact dealing with Sergeant Medland's evidence, and as Dr. Ellis accepted, the Court of Appeal, indeed upholding the judge, so there are concurrent findings which are not, as I understand it, challenged. Said at paragraphs 175 to 178 that effectively, although there was a challenge, it wasn't successful, and we must assume that the search warrant was sought in good faith on the basis on which it was apparently presented. So those points would help us, and I think you can take it we've read the whole of the rest of the material, and Dr. Ellis and Mr. Edgell have had a chance to deal with it, so we don't need you to cover it at all orally.
Certainly, Your Lord. The latter 2 points, 2 and 3, are within the remit of Mr. Raftery.
Yes.
I'll certainly address the first. If I may very briefly say that the first thing I have for your lordships today is...
I might just add, sorry, there was one point. We have sought through the library to obtain a copy of Hallsbury's 4th edition because the reference in the appellant's synopsis on page 1458, their paragraph 203 to Hallsbury, as suggesting that some form of notice might be required. That doesn't appear in the current Hallsbury, and we're uncertain as to what it refers to. We haven't been vouchsafed a copy of Hallsbury, so we can't look at the footnotes, but we're trying to obtain it, and if it comes in time, then we'll obviously produce it, but otherwise it'll have to be something that's looked at so far as it's relevant afterwards. And
Obliged, my lord, we've had the same difficulty.
right.
As I say, the first thing which your registrar will have placed in front of you this morning is dated today, 16 May.
Yes,
a
it's very
schedule
helpful,
of
cross-reference.
Cross-references, yes. What it does down the left-hand side is track through the learned defence submissions for the appellant.
Yeah, no, that's really helpful.
And the cross-reference to our case and then the court judgments.
Right, thank you.
And that might be a convenient moment for me to turn straight to your subsidiary point, namely what is new. Because the points where there is nothing in the right-hand column, and there is no judgment below, those are the ones which we say, in essence, are new. But I talked to my learned friend over the break. My suggestion to him was that as counsel we might jointly confer and present the board with a memorandum setting out what we agree to be new points before the board. And if there are any areas where we can't agree as to what's new, we'll say so.
Well, certainly if you're able to do that, but those are your submissions, that
Yes.
there's nothing there, and so it is by definition new.
Indeed.
I mean, I suppose it might have been raised at some other place or point in time in some other way apart from the state of the claim, or but it doesn't appear in the judgment, then you say it's a pretty clear indication. Yeah, right.
That's right. So far then is the first question, what requires permission? That is a topic which takes me to the memorandum filed on the 9th of May, just a short memorandum which your lordships ought to have. I think it may have had an orange
Yes,
tab
we've got
on it.
that, yes.
The short point, my lords, is that depending on the view you take of this case, it's possible that all of the substantive points do require permission. The point arises in this way. The case is before you pursuant to leave granted under Section 25 of the Constitution.
Yeah.
It's an appeal as of right, but the Court of Appeal, in accordance with your usual practice, confirmed the existence of that right. Section 25, which is in part set out in the memorandum, but if you want to look at it in full, it's in volume 9, page 2889.
Right.
There's a provision which is found in a number of the overseas territory constitutions. So it was page 2889
Yeah.
of volume 9.
Yes, it's the adequate means of redress.
That's the point. That's
And
the
they
point.
did, you say, the courts below did decline effectively to exercise their jurisdiction.
That was the square basis on which all courts below determined the Section 25 point.
Yeah.
And so in formal terms, that is the question before the board, the first question: were the courts below correct in determining that there are adequate means of redress available, were adequate means of redress available to the appellant? Our submission is that that finding was an orthodox application of the section and of the principles that the Privy Council has articulated in cases going back to the 1970s, such as Harikissoon, Jaru, Jurity.
Yes, quite. We know the.
You know the principles.
How does it apply in this context? We're talking here about criminal proceedings and procedural applications made in their course. And, I mean, what is the alternative means of redress? How does it differ from what was actually applied for? What was actually applied for may have been put as a constitutional relief, but it said it could equally well be put as lack of fair trial.
Yes.
Is it all right if it had been put in the latter context? And you say that there's been no permission to appeal for straightforward failure, lack of fair trial. Is that the position?
My submission is that all three of the applications that the appellant made were expressed as alternative submissions seeking both redress in the criminal jurisdiction.
Yes, I see.
And constitutional redress, effectively concurrent applications.
Yeah. Can we look at one of those?
Certainly, Lord. They're found in Volume 2. Three, I'll take you first to the third, which is at page 604.
Right, yeah. Yes, as though I conjoined. Yes.
Yes, indeed. It's very clear on the face of the document from the top left-hand corner and at the top of page 605 as well, that it was a concurrent application under the Constitution and seeking redress as an abusive process application.
But relying on the same things.
Yes, yes.
So, and what you say, the procedural position is, you say, that they were given permission insofar as there is a legitimate constitutional challenge, because that's an as-of-right situation, but Court below left it to us to say whether there should be permission on the abuse.
Indeed. So far as the regular criminal jurisdiction is concerned, that of course requires permission. The Section 25 argument, if your lordships were so minded, could be disposed on the simple basis that the courts below were correct that there were alternative means of redress.
Yeah, no, we have the point. Right, thank you.
Perhaps just to anticipate what my learned friend may say by way of response, the second of the three applications was in the same terms as the third, abusive process or constitutional relief. So very straightforward. The first of the three...
What was the reference to the second one?
The second one is in the same volume beginning at page 591.
Right, yep.
So again, squarely, it's really 592, I suppose, is the operative page.
Yes, and sorry, the first one then?
And then the first one begins at page 466. The operative part begins at 467. So it was constitutional challenge and or by way of appeal from the Magistrates' Court.
Yeah.
This, just for completeness, this application was then amended on the 29th of September 2011. That's at 471.
So what's the alternative relief here?
Well, if we look at 472, which is the relief pleaded in the amended application, what was sought was a stay of proceedings. Now, we say, of course, that a stay is a well-known remedy available to the criminal courts by way of abuse of process.
Yeah. It probably doesn't matter even if they didn't apply for abuse, because
Quite.
it could have been, they could have done, is your case. Yeah. Yeah.
That's right.
Right, well, that's helpful.
Our submission, of course, is that this appellant was before the Supreme Court of Pitcairn, which has all of the jurisdiction of the High Court of England. So he was before a court of full jurisdiction with all of the criminal remedies available. They, of course, include exclusion of evidence if that were appropriate, stay for abuse, or insofar as the argument was, as it was, that the court itself lacked independence and so on, in order declining jurisdiction, which is a step that has been taken in a number of cases, including the Vallant case in the Supreme Court of Canada, that's in the bundle, and indeed...
What's it called again?
Valente, V-A-L-E-N-T-E, that's volume 8, at tab 32,
Yeah.
page 2803.
Right.
That, your lordships will see, was a regular criminal case that proceeded through the system and reached the stage where the criminal court said it would decline jurisdiction on the basis that it was not an independent tribunal because it lacked the necessary protections as to remuneration and so on.
Yeah.
It then proceeded through the system as a regular criminal appeal, both sides appealing in various ways, to the Supreme Court of Canada. That's the first example of the way in which the various points about independence and so on can be advanced within the regular criminal process.
His trial, I mean, these are in form, in part, are they, preliminary applications to the Court of Trial?
Yes, that's right.
Trial is in the Supreme Court, isn't
That's
it?
correct, yes, yes.
Therefore, binding rulings could be given, could they, on questions of admissibility?
Yes, yes. Pursuant to a provision of the local Pitcairn Ordinance, section 70AA of the Justice Ordinance permits that.
70 double A.
70AA, yes.
Right.
The other example, and it's of perhaps some brief historical interest, it's not a case that is in the bundle, but I can tell your lordships about it, and if you wish I can hand up copies. But the other case in which a regular criminal court dealt with issues of the validity of the whole system is in fact a Pitcairn case from the 1950s. And it arose from a charge, or two charges brought against a man called Floyd McCoy. He was a very vigorous and controversial police officer in Pitcairn Island. So controversial that in fact the locals charged him with offences. He was convicted by the local magistrates court and he appealed to the Supreme Court of Fiji. The Supreme Court of Fiji was said to have jurisdiction pursuant to some 1940 laws that had been passed by the High Commissioner for Pitcairn. When the Supreme Court of Fiji was confronted with this application, it said that regime was unlawful. The legal regime for Pitcairn, which had been in effect for about a decade, was ultra vires the High Commissioner's powers, and so the Chief Justice of Fiji declined jurisdiction in that case. So this is a case called McCoy in 1951.
Yeah.
That case led to an order in council in 1952, which for the first time created a governor of Pitcairn who had full legislative power under a peace, order and good governance standard. So as I say, from a humble criminal case, that actually achieved the very purpose that this appellant had sought to achieve, namely the a finding of invalidity as to the whole Pitcairn legal regime.
Yeah. Well, you might hand the copies of that in.
If I may, I'll pass them through your registrar.
Yes, of course.
Yes.
Yes, the usher will help. Yeah. Right. So we can probably move on, can we, from the points about permission?
I believe we can, my Lord, in which case we're through to Mr. Raftery so far as the 2 points on
Yes.
the criminal case.
Thank you very much indeed.
Thank you, my Lord.
Mr. Attorney. Yes, Mr. Raftery.
perhaps, my lord, we can deal with the first one, which was the apparent bias of the island magistrate.
Right.
I just had some references, maybe for your lordship, that might help in respect of that. First of all, the findings of the Court of Appeal, which you've already referred to, so I presume that you have those. I don't know if you're at your fingertips, is perhaps putting it too highly, but you may not need help on that. That was dealt with in the Court of Appeal, and their paragraphs 175 onwards. And they endorse, well, not endorse, they accept the findings of Justices Lovell Smith and Justice Haynes. And Justice Haynes, perhaps more graphically than Justice Lovell Smith, who recites the facts, the evidence that she's accepted as correct. It may be just of interest to note that the comments of Justice Haynes in respect of Sergeant Medland gave evidence, as I think I mentioned before, or you were told before both judges, in respect of the search warrants, but on different aspects. And when Justice Haynes was being asked to deal with them, it was agreed between my learned friend and I that what was said and happened before Justice Lovell Smith didn't need to be reinvented or gone through. We could just accept that, and he could add on to that. And he did. But at it's page 203 of the file. I don't know that your lordship doesn't need to turn it up, but Justice Haynes said at paragraph 155, little c of his judgment, having seen and heard Sergeant Medland give evidence, I have no reason to doubt his integrity and honesty. His evidence was given in a forthright and frank manner. Without hesitation, I accept him as an entirely credible witness. Yeah. And by implication, as did Justice Lovell Smith in her recitation of what she accepted from him as to the facts.
Yeah. No, well, I think that point is not one I mean, it's helpful to have the reference, but we don't require you to...
No, I wasn't going to develop that further. But in respect of then the
island magistrate.
The island magistrate is concerned. They have... just give me one moment.
I mean, the argument which you have to deal with is... we can look at the way the Court of Appeal and Justice Haynes dealt with it, but the argument is that they are rather closely involved with one another, and in a small community, is it really right that the island magistrate should be issuing against his immediate superior a search warrant, especially when there's an opportunity of actually taking someone off the island?
It's correct, there is an opportunity. There are other magistrates available, I accept that. One of the themes that your lordships will have noted from my learned friend Mr. Ellis's, or Dr. Ellis's submissions, is the, what I might call the paternalistic sort of approach of the United Kingdom, and hardly involving the islanders at all. There is a value, if there is an island magistrate, of using him for these, if at all possible.
But who took the decision? He presumably was the initiator, because he was the chap who spotted the problem. And,
yes, and
so, I mean, we say that there's a value in using him. And
yes, Sergeant Medland, as you've just heard, he consulted others in New Zealand, including
as to who to apply to?
Well, as to where and what to do next, basically, because of those concerns.
The search warrant was held.
And he received advice from New Zealand police officers and from the Public Prosecutor's Office in New Zealand that it was appropriate to apply to the island magistrate.
Right, so there's no evidence, though, is there, suggesting that he addressed his mind to this particular problem?
No, not specifically, should I go to a foreign magistrate in the sense of someone in New Zealand. But bearing in mind the fact that what the judicial officer is going to do is, if he accepts it, issue a search warrant. Whatever happens to that search warrant, you're going to get, as you did in this case, a review by 2 Supreme Court judges, and then the Court of Appeal of the whole circumstances in which it was issued. So that looking at the De Haan case, De Haan in the Netherlands, and all those other cases that we cite in our submissions, it has been reviewed by senior judicial officers at Supreme Court and Court of Appeal level, so that check and balance is there if there's a danger of there being a degree of bias or apparent bias in the behaviour of the island magistrate in issuing the search warrant against what you would call his superior officer. One of the factors, as I think Justice Lovell-Smith noted, and Your Lordship, within a population of about 50, give or take, I mean, it just needs one person to leave the island and it's decreased its population by 2%, so that it's a very small community. And if you take out of the fact that there are some children included in that, I mean, at the last census, as it were, of Pitcairn Island, at the end of 2017, it was actually in the early 40s, really, is what it amounts to. Most people, adults on Pitcairn Island, if they're not of a certain age where they're no longer functioning or working, other than as retired people, have more than one job. Everyone's related to everyone. They're all cousins. And so you're going, except for actually this particular Mr. Young, who is not originally an islander. He's someone who's now been given permission to live on the island. He, with his American wife, arrived in search of Shangri-La and felt that they had found it. And after a long battle, they've been given residence on the island. I'm not sure they've been given British Overseas Territory citizenship or not, but they now live on the island.
Where do they come from?
Well, he comes from England and she comes from America.
Okay.
And so that but anyone else is going to be related somewhere or another to Mr. Warren.
Yeah.
And so there is at least that one advantage, that he's the one person who isn't related to him by any sort of blood connection whatsoever.
Well, yes, but the suggested alternatives are not other people on the island.
No, I appreciate that. I appreciate that completely. But bearing in mind what you have got here, and going back to the point I was making, is a warrant that is capable of being reviewed by senior judicial officers, that any danger in that is slight. I mean, in terms of the well-informed observer, who's, to paraphrase the language of the courts, clued in and well-informed and uses a bit of robust common sense, they would say, well, here is a man who could not get that job de jure unless Mr. Warren was convicted and sentenced to imprisonment, which is section 3.2 of the ordinance that applied, the local government ordinance that applied at the time. There are other opportunities if he was unable to perform his functions where he would have to step in. But in terms of getting the job, if he pined for it, there was 6 months left to run of Mr. Warren's present office, and we know the elections would happen in December of 2015, when his automatic stepping into the shoes would come to an end. So looking at that informed observer, he's got to say, well, to himself, there will be a conviction and a sentence of imprisonment between now and, well, maybe October, so at least I'll get a month in the job. The informed observer would say there's a slight air of unreality about that, and that, with due respect, is essentially the Crown argument, that there really isn't any, there's no actual bias alleged. The only allegation is there's an appearance of bias, and when the informed observer examines those sorts of facts, they say, well, in reality, there wasn't any real bias, and there's no danger that this person was motivated or could be seen to be motivated by trying to get the job, because the informed observer would have to know the provisions of section 3.2 of the local government ordinance.
Why does it follow as a matter of local practicalities that the expectation of succession would come to an end in December 2015?
Well, in December...
I don't know how realistic elections are for the function.
Well, they're actually taken quite seriously. It's all adult suffrage, it's compulsory to vote. Right. Bearing in mind there aren't many of them, it's quite a social occasion on the Pitcairn calendar, as you know, there aren't many other occasions of this sort. And so people fight for the job and they contest the seats as councillors.
There is a contest, is there?
There is a
contest, is there?
Oh, yes.
Okay, well, in that case I understand why you say what you do.
Yes.
So it's basically like 18th century style hustings, is it?
Well, a bit, yes. A bit like that. Much of Pitcairn has a certain 18th century ring about it because of the history it brings to it. And even in some of the language which hasn't, of English terms which haven't moved much beyond it. You know, things like, we always refer to guns as muskets and things of that sort. So there's a certain quaintness about it. But the reality is, that's why I say that all he could have obtained, that he really was secretly trying to get that job, was, say the wrong phrase, but not very much. And it, again, bearing in mind what the informed observer would be expected to know, it doesn't really cut the mustard as it didn't with either judge in the Supreme Court nor with the Court of Appeal.
There's no evidence of any ill will or anything like that. It has to be simply a sort of inferred risk of bias, because he might be interested in getting the job and do it for effectively. Yes, or his judgment might be biased. Yeah.
Bearing in mind it took 6 years to get to trial in this case, he might have been a bit optimistic, thinking it had all been over and a sentence of imprisonment achieved in less than 6 months.
Well, I suppose somebody might think that the mayor would resign or be forced to resign, but although it was suggested, it didn't happen.
Yes, and there was some mention in my learned friend's written submissions about that the governor asked him to resign. I think it's based on a letter from, I think, the deputy governor, or maybe the governor to Sergeant Meslin, that the governor was standing by ready to suggest his resignation if he wished to do so. He didn't wish to do so, and the governor didn't force the point, and he continued. And the charges weren't laid till the following year anyway, and he just stood for election before the charges were laid and got in for the next 3 years. But he didn't, because he only do 2 terms anyway under the local government ordinance, and that was it.
Mr. Raftery, I think the case against you may be put on a different basis in the alternative, which is that Mr. Young had a financial interest in the outcome. And if that's right, then on the basis of dimes, it's not necessary to show appearance of bias. I'm not sure that there was actually any evidence anywhere that, and I'll be correcting my learned friend, because I couldn't find it as to whether what the difference in salary was, if there was a difference between mayor and deputy mayor. Yeah. But again, the same point really would arise about what I'm just saying, although you don't need to show the apparent bias. Bearing in mind the reality of he's got to have a sentence of imprisonment to be able to guarantee that he can step in within 7 days of failing to resign.
It's a very contingent.
Yes.
Very contingent.
So the financial, an actual direct interest in as a shareholder.
Yes.
And I mean, he's not yet a shareholder.
No.
The suggestion is he might want
Absolutely.
to become one.
Yeah. So that, with respect, my Lord, I think it's really the same point answers both of the what I might call limbs of apparent bias.
Thank you.
Well, do you want to say anything on the other limb of the argument? If we were against you on that limb, we get to the question of discretion. Is there anything more to say?
I don't think so, my Lord. Just one thing that my learned friend, the attorney, has asked me just to correct. Apparently, I mentioned elections in December 2015, and I should have said 2010.
Yeah.
If any of your lordships spotted it as the sharp ears of my learned friend, the attorney, had.
I think we were focusing on the only 6 months to go. And we assume that didn't take us till now. 15. Right, so...
And the next point, then, my lords, unless you want me to say anything, that was Section 8 versus Section 160.
Exactly, yes, no, that's a point we want to hear on.
You will, of course, be well aware, my lords, of the case of Christian and the Queen from 2006. And those men in those series of trials that came here were prosecuted under the Sexual Offences Act 1956, when they could have been, and in respect to one or two matters, they were originally charged under certain local ordinances of indecent conduct. And what the board found on that occasion was that it was entirely appropriate for the Crown to seek to charge for the more serious type of offending pursuant to the English statute, rather than to use the local ordinance. And in effect, that's what's happening. That's what happened here, in that a decision was made to charge under the Section 160 of the United Kingdom Act because of the seriousness of the material that was then discovered.
No, the complaint isn't about the decision to charge. It's rather more far-reaching than that. submission is that Section 160 wasn't in force at all and wasn't available as an option.
Yes, I understand that, my Lord, and I'm just going to come back, but I'm just going that was the background against which the matter of Section 160 was charged, and just in respect of some of the matters that my learned friend mentioned, just to say this, your Lordships are aware that in the evidence of Sergeant Medland, which we know was accepted, he said when applying for the warrant under Section 8, that after consideration of the matter, particularly with the public prosecutor, it was not felt there was enough evidence at that stage.
Yes, well, we've got that point.
I'm grateful, Lord.
Yeah.
I was just going to say I've got the chapter and verse if you needed it.
Yeah, we've got it. Well, we've got the chapter and verse for Sergeant Medland's evidence, have we?
Sergeant Medland's evidence, yes.
Yeah, well, just give us that then, because we've got the Court of Appeal and...
Yes, I'll just make sure. Page 979 of the record.
Yeah.
I'm sorry, I use off the electronics, so I haven't got the volume reference. It's volume 3, I think.
Don't worry,
Yes.
we can look it up.
But it's page 979,
Yeah,
and
that's the transcript.
line 3, the answer given at line 3, 4 and 5 to questions from Mr. Ellis encapsulates. There's much more evidence, but there where he says that why he chose that course. Consideration had been given to whether there were other offences more serious, but it's a question of what could be said to be believed at that time rather than suspected or thought might be the case.
Right, let's go back to the
Section
the
8.
legal point then.
Yes.
Is the Act in existence, or was the Act in existence?
And the only reason why my learned friend says the Act is not in existence is because Section 8 ousts it, as I understand my learned friend's argument, because of the existence of the that measure in the Pitcairn Ordinance and the fact that it all happened at the same sort of time, the 2000 revision. As far as trying to find an earlier version of the material, which one of your Lordships asked for, I think it may mean my Lord who did, there's nothing in the agreed record at the moment. But there, having looked on what's available on our computers, we can go back as far as the 1966 Justice Ordinance that has Section 8 in that form there, but it's then in the Justice Ordinance. But we have the 1975 revised edition on our machines. So I don't know how further back it goes than that, but certainly that Section 8 offence, although it was...
Been there a long time.
Has been there a long time.
And so we'll just trace through the course of history. That's there, and then there is... presumably an equivalent, that's a general offence. There's nothing specific to children.
Children, no.
At all. And the UK legislation, do we know what that has at that stage? I think...
No, and in the time when the issue obviously arose of concerned lordships, I was looking to see what was available for Pitcairn at that time. But what I would say as a general proposition, it must be accepted in the Crown submission that governors of Pitcairn, when legislating for Pitcairn...
I mean, no doubt, just putting it bluntly, Section 8 is a general section.
Yes.
The proposition which I think Mr. Edgener was inclined to accept was that there would have been found in the English legislation a similar section covering obscene material, indecent material, but there was also the early equivalent of Section 160 dealing specifically with child offences. And you then ask yourself, is there any reason why that earlier version of Section 160 as a sort of lex specialis, a special law dealing with children, should not apply in Pitcairn whenever it first came in? And then you ask yourself, is there any reason why when it was expanded to become an indictable offence, that shouldn't also apply?
Exactly, my Lord.
And as far as one can see, all the sexual offences ordinance of December 2000, and whenever it is, which year are we talking about?
I mean the
Pitcairn one, all the one that did was reenact something which you tell us was in the 1966 Justice Ordinance.
That's correct.
So,
and in effect, not there particularly in the material, but as your Lordship's aware in a general way, the issue that was before the board in 2006 arose out of what was called Operation Unique, by the Kent police who were investigating it, triggered by a complaint by a young girl in December 1999, and then she was taken off island to her grandparents in New Zealand and investigated from the year 2000 onwards, that in the year 2000, suddenly there was a flurry of activity of superior courts that had been dormant in Pitcairn for some time because there had been no call on their services. The legal advisor, Mr. Treadwell, was looking at the ordinances that existed, what needed basically a bit of republishing and a bit of reorganization, and maybe finding lacuna that might need to be attended to if there were going to be any prosecutions following the investigations that were then pursued. So that's why you got a certain amount of activity in the year 2000, effectively by the legal advisor, Mr. Treadwell, rather than by the governor just looking at stuff, and there's some new ordinances to cater for what was necessary. And so that's why not much, having happened sort of intermittently over the years, not much happened until the year 2000. And that may explain quite a lot of the things that happened in that year. But any governor of Pitcairn will know that the precursor to Section 42 of the 2010 Act were the Pitcairn Ordinance, the Pitcairn Royal Instructions, and the Pitcairn Ordnance Council of, first of all, 1952, then 1970. And they had the same sort of provision that the laws of England, the common law, and the statutes of general application applied on Pitcairn, so that any governor will know that, and in fact the history of Pitcairn that was, and what I might call the juridical history of Pitcairn that was explored in the 2006 case, showed that the islanders were well aware that serious offences were dealt with under English law. I think we'll see that briefly in the judgment of the board in 2006, and that was something that any governor of Pitcairn would know, as indeed would any Pitcairner. And so what there is in this case, when you've got Section 8, I think it's a point some of your lordships have already made to my learned friends, a very general one of indecent articles, possession of indecent articles or importing indecent articles. And then you've got the very child-specific concern about child pornography. And so there really is not apples, comparing apples with apples in effect. So that any governor bringing in new legislation in 2000 or updating it wouldn't see any need, in my respectful submission, to do anything more than saying, well, the serious stuff is already accounted for by the fact that it's incorporated into New Zealand, into Pitcairn law by virtue of the predecessor to Section 42.
Well, that's very helpful.
Nothing more, my lord, then that's it.
Thank you very much indeed.
Thank you.
Yes. Dr. Ayres.
Well, as to the first issue, the Lords, the question of permission really revolves, I think we've been there already. Do we or do we not raise a constitutional challenge when the issues are as wide as, does the Bill of Rights 1688 apply? Is there democracy? All honing in on the question of a fair trial, and the issue of what the Supreme Court of Canada said in 1965, 85 I think it was, yes, 1985, or the decision of the Chief Justice of Fiji in his Pitcairn jurisdiction in 1951 have got to be read in the light of what does the Constitution say in 2010. And there's plainly a discrepancy and an absurdity in the Constitution mentioning 8 times free and democratic society and then not having a free and democratic society. So how do you challenge that? Well, I chose to challenge it, as you saw, by bringing a constitutional challenge, an abuse of process, and also a challenge to the under the 1688 Bill of Rights. for right or wrong, because as you've already heard my arguments about the judicial review, it wasn't at all clear there was a process or how it would ever be funded. So I took that and we followed it to here. I've said if we haven't got a right, then we apply for permission in the written submissions, and I don't think I can go round the circuit again. So that's that situation. It's all about fair trial, democracy, and the Constitution. The second point, the apparent bias of the magistrate and the availability of 4 New Zealand-based magistrates really does say there was no reason to do the search warrant before a Pitcairn magistrate, and we had, which I suppose I just want to make a concession here so that you don't go round section 78 again. For right or wrong, I spent days cross-examining Sergeant Medland on all sorts of points, and we were at the high moral level of the South African Supreme Court case that the warrant was unlawful, and even that the police officer was not acting as an independent police officer of Pitcairn. I did not, and in hindsight that may well have been a mistake, go beyond section 78 of PACE. I did not address code E, I think it is, of PACE about search warrants. That was not an issue because we had other things in play. So, but what returning to where I am, the officer was having a discussion. Have you found it? Yes, on volume 3 at 922, the supplementary brief of Sergeant Medland about how the warrant was obtained, and there was the registrar on the phone in New Zealand residing in the offices of Meredith Connell, the Crown Solicitors, which I did take the point that was unlawful. He shouldn't be. That's not independent. And the island magistrate and the police officer were in the island magistrate's house, and the police officers were waiting in the spare bedroom of the police officer while this conversation is going on with the registrar and the prosecutor, who've joined together. So the whole aspect of how the warrant was issued was dealt with extensively, and I agree that Dimes and is it Grand Union Canal or something like that, there's a financial aspect, but I did also say there's a status aspect in that you become mayor, and that's very important on the island as well as status. And my learned friend is quite right in saying there is no evidence of what the salary of the mayor or the deputy mayor was, but it was assumed there was some difference because everybody on the island seems to have 3 or 4 jobs, so the magistrate was a quarantine officer and something else as well. So that it really was quite wrong in the local circumstances of Pitcairn, and especially given the about Sergeant Medland on where at page 701, 700 and in volume 3, job sheets about possession of obscene articles under section 8 of the Summary Offences Ordinance. That page led to a multitude of challenges, 700 and 701. I inadvertently told you that not only did he seek seek support from New Zealand, but he did from the Kent Police. I see that should have been the Hampshire Police.
No.
But it was the Hampshire Police paedophile unit. So he was obviously on to the fact that there was something serious going on there, and you'll see he had...
What's the date of the execution of the warrant?
Don't know, we'd have to look that up.
All right, don't worry, we'll find it.
Don't know.
No, it's sometime in late May, by the look of it.
Yes.
6th of May.
Thank you very much.
And it was, of course, a warrant executed on his office and also his home. And in his office, there was the seizure of a number of financial records which were detailed in the written submission. So it was the argument that the warrant was overbroad and shouldn't have been allowed in. Anyway, the point in your court is that its apparent bias cannot be disposed of simply because there's a small island when there's 4 readily available alternatives and there's a financial and or a status interest. And then on the third point, the Section 8, Section 106 controversy, well, Section 8, of course, quite rightly, as Lord Mant says, is a general proposition, but it's a general proposition that includes the ability to catch offences under both adult and child offences. And when one reads the words of the section, it's quite clearly getting at obscene material obtained electronically. And what I think is missing in the argument is the local community expectations and tariffs for what was going on here. And we had, as my friend raised, Operation Unique, and if you systematically raped and or indecently assaulted children on the island, you might get, I think 6 years was the most, was it? 6 years. And here we are, we're now moving to somebody's in possession of child pornography obtained on the internet, nothing to do with children on the island, and we're trying to impose a 5-year maximum on it. It's not in the culture of the island to imprison people for that long. Rarely is anybody ever imprisoned. The Operation Unique people were, and apart from that, there's minor offences where the local magistrate can sentence you to 100 days. So it's really out of kilter to suggest that one should rely upon an English offence about children. If the governor had wanted to change the local tariff, then he should have done so. And that is why Section 8 covers the field. And it is not just that, well, there's the English Child Protection Act, which there clearly is, because Section 160, the last section in the submissions subsection, says it does, and there's no question that it does. And there can be...
Sorry, there's no question that
that the child protection is referred to in the Criminal Justice Act,
yeah, right.
Section 160.
Right.
Nevertheless, the local ordinance is quite capable of dealing with it, and in the light of the culture of Pitcairn, it wasn't raised. And as my junior said, in New Zealand, we had originally it wasn't even imprisonable having child sexual images, and in Britain it was a maximum of 6 months until I forgot the date, 2000. So that has to be factored into misuse of the internet, because if the island was going to take the matter as seriously as a 5-year maximum, then one would have thought, we saw the governor and the police officer going to a course on child protection, and no doubt that's laudable. I don't think they should have done it together. The optional protocol on child pornography to the Convention on the Rights of the Child was not extended to Pitcairn, and there is a disparity in the thinking and of the issue of the warrant under a local ordinance. And I just wanted to say, probably a little off point, the terrorism point. If one looks at the list of ordinances for Pitcairn, there is none for terrorism. There's 3 or 4 that relate to English orders, the United Nations order, section.
Yes, I mean, I think you can say that the operation of the Constitution, section 42.2, all laws of England shall be in force in Pitcairn so far only as local circumstances and the limits of local jurisdiction permit, and subject to any existing or future ordinance. It doesn't give you exactly very precise information as to which apply.
But the culture of...
Yes, we've got your point on the culture.
Slightly different point, of adopting United Kingdom laws. There's a whole raft of United Kingdom laws found on the Pitcairn Island government website relating to terrorism, money laundering,
yes,
etc. There's no one that says child pornography, so it could have said that, but it didn't. But there's a whole raft of international propositions that ought to be in place, sanctions, Syria and Rwanda and so on.
I don't think we can decide what is Pitcairn law by reference to the government website, can we?
Yes, government. If we go to the Pitcairn Island website, under government it says laws, and then there's a link which says all the laws, that the United Kingdom laws that have been placed on Pitcairn from 2006 to date, which are probably about 100, and then 2000 and something else.
Well, you're telling us that the Criminal Justice Act is not one of those?
Yes, it's not one of those. And if it had been intended to be, it could have been.
Right.
So, apart from that, it's been a privilege to be here and put the case. I think I was last here when Baroness Hale had her first day here, which must have been 2003. Don't suppose I'll be back again. It's been an honour to be here and to be listened to with such intensity, and I thank you, and those are our submissions in reply.
Thank you very much indeed. That's very...
Yesterday, something I have found an answer about how often the governor visited Pitcairn, and I've just checked with the immediate past governor who's in the back of Corton. He went twice during his term of office, would have gone a third time, but he was sick. But he had monthly Skype calls with the island and with the island council. So on a monthly basis, he was in contact.
How long was his term of office?
4 years? 3 years, but 3.5 years.
How long
so
does
it would
it
have been
take?
once a year, but then there's that monthly.
How long does it take to get to Pitcairn? 3,500 miles?
Well, you fly to Tahiti,
Oh, you fly.
and then you catch a boat.
Yes, I see.
So usually you leave on a Sunday and you arrive on a Thursday. By the time.
Right. I should just mention, and perhaps we could just look at it before we adjourn, if you could hand out those. We've got copies of the relevant Hallsbury. We perhaps ought to just let Dr. Ellis.
Thank you. Let's have a look.
I think this appears in your synopsis at 1458, doesn't it? Dr. Ellis, what you've done is quoted to us two paragraphs which are actually dealing with different subject matters. The first one seems to deal with provisional orders. The second paragraph, 1406, is under the head special procedure orders, and this is subject to paragraph 1405, which indicates that 1406 is only concerned with acts passed since 1945 under which there is a power to make or confirm orders conferred on any authority. Apparently power has been conferred to make orders in council extending special parliamentary procedures to orders made under enactments passed before 1st June 1946, but that's said to be in substitution for provisional order procedure. You're relying, as I understand it, on something which relates to special procedure orders, because you're relying on paragraph 1406, the notice in the London Gazette or to a newspaper circulating in the relevant area. On the face of it, it doesn't seem that we are within special parliamentary procedures, even if this applies to the type of order in council we're concerned with at all.
Well, it did seem to be.
This seems to be dealing with delegated legislation, doesn't it, rather than orders in council. I suppose maybe the Colonial Validity Laws Act gives rise to a form of delegated legislation.
Yeah, I do believe so, and I suppose the general point I was trying to make, I was once the clerk assistant of the New Zealand House of Representatives, and before any non-government bill was in, it had to be advertised 3 times in the local newspaper and so on. And this seems to be a common theme across Australia too.
I know, but what you've got to do if you're challenging an order in council under the 1867 Act is tie it down to some provision, which I think at the moment hasn't been done, which actually deals with the 1867 Act or the types of order in council issued under that Act.
Well, I understand that, sir, and the proposition is that the 1867 Act does not allow, as a matter of virus, retrospective and permanent legislation.
Yeah. I thought the proposition was invalid because there wasn't
because it wasn't published, and that's, as I said, I had a second string, which was natural justice requires that those that are affected are going to be told, and we saw that the government suggested that all draft legislation, albeit not specifying whether it was local or UK, would be addressed to the Island Council. And why shouldn't it be? In a modern age...
Well, one can see that. Those are arguments of general convenience, but I referred wrongly to the Colonial Rules of Validity Act. I meant the British Settlements Act, 1867. 1887, sorry. Yeah. We've got to find something which applies to that, and it doesn't seem to be this. But if you think the contrary, you can communicate it. But can we have any further submissions on this point within a very short time, say 10 days or?
Right. Well, obviously, I'll read this with more.
But I don't. On the face of it, it doesn't look as if these provisions apply. If there is anything which you actually suggest applies, then do let us have it.
Right, certainly. I thank you for that opportunity.
Good. Right. Well, the board is grateful to council for their extensive written cases, and will take time to consider what advice it will humbly tender to Her Majesty. They're adjourned.